Have you ever wondered what actually happens when you're named as an executor in Texas? Welcome to this explainer. Today, we're diving into a topic that feels like a daunting legal maze, but is absolutely essential: the Texas probate process. Specifically, we are going to break down exactly how to get letters testamentary in Texas step by step. These letters are the critical tool that empowers executors to legally manage an estate. If you've recently lost a loved one, you might be feeling overwhelmed by all the legal jargon. But don't worry, we're going to transform all that confusion into total confidence right here.
Let's kick things off with a really provocative question. Does a will actually give you power before it enters probate? You might assume that just holding the original last will and testament with your name printed right there as the executor means you can just walk into a bank and take over. Well, surprisingly, the answer is a resounding no. Under Texas law, an unprobated will grants you absolutely zero authority. It does nothing to prove title or possession until a court officially admits it to probate and hands you the correct legal document.
So here is our executor's roadmap for this explainer. First, what are letters testamentary? Then we'll cover preparing and filing, navigating the court hearing, your key duties, avoiding common pitfalls, and finally, a quick conclusion and disclaimer. Section 1. What are letters testamentary? The golden key to the estate.
Think of this document as your ultimate goal in the initial probate process. By definition, letters testamentary are court-issued documents that grant an executor the legal authority to manage and distribute a deceased person's estate. And what's really fascinating here is just how absolute this rule is. Without this vital instrument, you have absolutely no unilateral authority to access bank accounts, do financial transactions, sell real estate, or pay off debts. This piece of paper is literally your mandatory license. It is the only thing that forces banks, title companies, and other institutions to recognize your legal power to act on behalf of the deceased.
Now, this brings up a crucial distinction we need to clear up right away. What exact document are you applying for? It all comes down to whether or not there is a will. If the person died testate, which means they left a valid will naming an executor, you apply for letters testamentary. But if they died intestate, meaning there is no will, the court issues what are called letters of administration to an appointed administrator. For our explainer today, we are focusing strictly on the testate path, securing those letters testamentary.
Section 2. Preparing and filing the application. Gathering your legal armor.
Before you even think about approaching the courthouse, you have got to gather your legal armor. Preparation here is everything, so let's look at this pre-filing checklist. First, and this is absolutely critical, you must find the original physical will. Texas law heavily favors the original document. If you only have a photocopy, you're going to face a much more complex and expensive procedural hurdle to prove its validity. Second, you'll need to obtain multiple certified copies of the death certificate. And third, verify that you actually meet the legal qualifications to serve as executor, which we're going to touch on a little later.
Once your documents are ready, your attorney will draft and file the application for probate. According to Texas Estates Code 256.052, this application has some very strict requirements. You typically file it in the county where the deceased lived. The petition has to include specific details, like the domicile and age of the decedent. Plus, you need to include the last 3 digits of both your Social Security and driver's license numbers, as well as the decedent's. You'll also need to list a general description and the probable value of the estate's assets.
Now pay close attention to this fast-approaching deadline: 3 days. After your attorney electronically files that application, local Texas rules almost always require that the original, physical will be delivered to the county clerk's office within just 3 days. If you fail to hand over the original will in that incredibly tight window, your case could be severely delayed or completely canceled.
Section 3. Navigating the court hearing. Crossing the legal threshold.
Okay, so you filed the paperwork, but don't expect to see a judge the very next day. There is a mandatory waiting period built right into the timeline. The court clerk is legally required to post a public notice, known as a citation, at the courthouse. This posting period usually lasts about 2 weeks. The whole point of this is to give anyone with a potential interest in the estate, like a creditor or an heir who might want to object, a chance to come forward. Once that 2-week period clears without issue, you can finally get your court date on the calendar. When hearing day arrives, it's usually quite brief, especially if the will is uncontested. You'll basically give testimony under oath. The judge will want to confirm that the person has indeed passed away, verify that their specific court has jurisdiction, and prove the validity of the will. Assuming all goes smoothly, you will then take the official oath of office, where you swear to perform your duties. You might also have to post a surety bond to protect the estate, but honestly, most well-drafted wills actually waive this bond requirement completely.
Boom, congratulations, the judge has approved your appointment. But before you walk out of that courthouse, there is one immediate logistical step you must take. Secure multiple certified copies of your brand new letters testamentary from the clerk. Why do you need multiple copies? Because banks and financial institutions are incredibly strict. Most of them will demand your letters be dated within the last 60 days, so you're likely going to need to purchase fresh, newly stamped copies periodically throughout the probate process as you deal with different institutions.
Section 4. Key duties of an executor. The trials of administration.
So you've got the letters, now what? Well, here's a piece of incredibly good news for folks in Texas. Roughly 80% of Texas probate cases qualify for what's called independent administration. This is a beautifully streamlined process. It basically means that once the judge appoints you, you can manage the estate's business, sell property, and pay debts with almost zero ongoing court supervision. It drastically reduces court costs and saves so much time compared to the probate process in other states.
But listen, even with independent administration, your fiduciary duties are incredibly strict and you are bound by very tight deadlines. Your core responsibilities include gathering up and protecting all the estate's assets. By law, you must officially notify all beneficiaries within 60 days of your appointment. Then, within 90 days, you have to file a comprehensive inventory, appraisements, and list of claims with the court detailing every single thing the decedent owned. You're also responsible for managing ongoing debts and ultimately distributing the remaining assets. You have a legal duty to make every decision transparently and in the beneficiary's absolute best interests.
Section 5. Avoiding common probate pitfalls. Navigating legal traps.
A huge part of this process is avoiding legal traps. The first thing is making sure you are legally allowed to serve in the first place so you don't file an application destined to fail. Texas Estates Code 304.03 outlines some very clear disqualifications. You cannot serve if you are under 18, legally incapacitated, or an unpardoned convicted felon. Now, if you live outside of Texas, you actually can still serve, but you absolutely must appoint a resident agent in Texas to accept legal documents on your behalf. And lastly, a judge always has the discretion to disqualify anyone they find generally unsuitable due to severe conflicts of interest.
Now check this out. There's the unique Texan shortcut called muniment of title that you really should be aware of. Sometimes you might not actually need a full probate or letters testamentary at all. If the court is satisfied that the estate has absolutely zero unpaid, unsecured debts, so no lingering credit card balances or medical bills, other than a mortgage on real estate, you can ask the judge to simply recognize the will as a valid link in the property's chain of title. It's a fantastic, highly efficient option, but it strictly only applies if the estate is virtually debt-free.
Another massive pitfall to avoid? Trying to DIY this whole thing. You might be tempted to save some money by proceeding pro se, meaning representing yourself without an attorney. However, probating a will without a lawyer is generally prohibited by local rules in Texas statutory probate courts. Why? Because as an executor, you are legally representing the interests of other people, namely the beneficiaries and the creditors. So acting without an attorney is actually considered the unauthorized practice of law in Texas. Long story short, you really need an experienced probate lawyer to guide you.
Section 6. Conclusion and legal disclaimer. Returning with a prize.
As we wrap up, I want you to keep this number burned into your memory. 4 years. Under Texas law, you have a strict, absolute deadline of 4 years from the exact date of the person's death to file their will for probate. If you wait too long and that 4-year mark passes, the courts will generally flat out refuse to admit the will. In that case, the estate will be distributed according to default intestacy laws, which could completely contradict what your loved one actually wanted.
And that brings us to our mandatory disclaimer. This explainer provides general educational information based on Texas statutes and legal sources. It is not legal advice. Every single estate is totally unique, and failing to abide by the strict rules of the Texas Estates Code can subject an executor to personal liability for a breach of fiduciary duty. Always consult a qualified Texas probate attorney to protect yourself and make sure you're fulfilling all your legal duties properly.
Well, we've covered a ton of ground today, from tracking down that original will to finally holding those freshly stamped letters testamentary. It's quite the journey from application to executor. So I'm going to leave you with this final thought. Are you prepared to take on that fiduciary duty and honor your loved one's final wishes?
It's a significant responsibility for sure, but with the right preparation and legal guidance, you can absolutely navigate it. Let us know your thoughts or share your own probate experiences down in the comments below. Keep learning, stay organized, and we'll see you in the next explainer.